All right, Ms. Tabram, who's ready at the jail?
I believe Mr. Brian Smith is. Schmidt.
All right, hang on just a second. I've got a little problem with my audio.
What did he do to us?
Mr. Schmidt, can you see and hear me?
I can, Your Honor.
Can you hear us?
Mr. Schmidt, can you say something for me?
Hello? Yes.
Got no audio here. Just one second. All right, I think we should be good now.
Can you hear me, Your Honor?
Yes, I've got you. Sorry about that. All right, is this Mr. Castillo?
Yes, Your Honor.
All right, this is cause numbers CR 22-319, CR 24-295, CR 24-296, State versus Gustavo Miguel Castillo. Mr. Castillo, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Florian. All right, before we get going in this, tell the court what the disposition is today. Mr. Schmidt.
Oh, me, Your Honor, that's fine. I will, Judge. I thought you were talking to the state. Your Honor, this will be a modification of his existing community supervision to safety, as well as eating up some back time that he has. Additionally, he will be pleading to 54 days on one of the cases with a $750 fine, credit for 54 days. The other case would be 54 days, credit 54 days, zero fine. It will be two unfiled misdemeanors that will be closed out without prosecution.
Okay, and on the probation case, we have is it a waiver or is it a plea true?
Judge, it's going to be an agreed modification, so there won't be a plea of true. We've signed an amendment, and the state's filing a motion to withdraw the motion to revoke.
Okay, and you said that the modification includes safety?
That is correct, Your Honor.
Okay. Do I have the paperwork on the modification? I don't see it if I do.
No, sir, I haven't.
You have it? Okay. All right. Mr. Castillo, I don't know if I've sworn you in yet. If you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Thank you. Can lower your hand. All right. Your name is Gustavo Miguel Castillo. Is that correct?
Yes, sir.
And Mr. Castillo, you're before the court on a motion to revoke and also two new charges. I want to first talk about the two new charges. And one charge, cause number CR 24-295. You are charged by information with a Class A misdemeanor offense of resisting arrest, search, or transport. And in cause number CR 24-296, you are charged by information with a Class A misdemeanor evading arrest or detention. In both of those cases, for that level of charge, the maximum time that you could spend in jail is up to 365 days. And you could also be fined up to a maximum $4,000. I see that the plea agreement in each one of these cases, it appears that in the resisting arrest case, upon his plea of guilt, the DA's office is recommending that the court convict him of this offense, assess his punishment within the range of punishment at 54 days confinement in the county jail, giving him credit for 54 days of time served, including a $750 fine. And the DA's office would be asking the court to dismiss and take into consideration 2 unfiled DA causes, a failure to ID as a fugitive, and also an assault causes bodily injury of a family member. In addition, you would be responsible for court costs of $270, reimbursement fees of $15, and a fine of $750. That's the resisting case. In the evading arrest or detention, upon your plea of guilt, the state is recommending that the court convict you of that offense and assess your punishment at 54 days confinement in the county jail with credit for 54 days of time already served. And you would be responsible for court costs of $270 and reimbursement fees of $15. Those are the 2 new charges. And then it appears that you have reached an agreement with the DA's office with regard to your motion to revoke, in which you would be asking the court to modify your conditions of community supervision to include a condition that you be attending the substance abuse felony punishment facility, also known as safety. And because I don't have that paperwork, Mr. Schmidt, is there a back time? Is he doing jail time or any of that being taken away on his probation?
Yes, Your Honor. It's 100. So in addition to the safety amendment, there's also 146 days in the county jail that he's serving as a condition of probation with 146 days credit. And he understands that essentially that's taking away his back time in the event he's revoked at a later date.
All right, great. Thank you, Mr. Schmidt. All right, Mr. Castillo, you understand all of that?
Yes, sir.
All right. And so just a few other questions. In this case, you are represented by your attorney, Mr. Brian Schmidt. Are you pleased with Mr. Schmidt and the work that he's done for you as your attorney?
Yes, sir.
Do you have any questions about any of the paperwork that you signed today?
No, sir.
Do you have any questions for Mr. Schmidt or the court before we go further?
No, sir.
Mr. Schmidt, do you believe Mr. Castillo to be competent?
Yes, Your Honor.
And do you believe that he is entering into each agreement intentionally, knowingly, and voluntarily?
Yes, Your Honor.
All right, then, Mr. Castillo, understanding the range of punishment that I've explained to you and also the plea agreements, I would ask you at this time in cause number CR 24-295, how do you plead to the Class A misdemeanor offense of resisting arrest, search, or transport?
Guilty.
In cause number CR 24-296, how do you plead to the Class A misdemeanor charge of evading arrest or detention?
Guilty.
And Mr. Castillo, are you pleading guilty to each one of these crimes respectively because you are guilty of committing each crime?
Yes, sir.
And Mr. Castillo, has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilty to each charge. Mr. Schmidt, any objection to the stipulation of evidence?
Objections.
All right, the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession in each cause. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, Judge. We were made aware that he's got a misdemeanor hold out of Hunt County. However, and he's got to get that resolved before he goes. So the sheriff's department here is going to teletype them. I'm also going to contact his court-appointed counsel because we want to get that resolved very quickly so he can get on the waiting list and get going.
Okay. All right, and Mr. Castillo, in cause number CR 22-319, you're currently on community supervision in this court for the second-degree felony offense of arson. Has anybody threatened, forced, or pressured you to ask for a modification of your community supervision to include substance abuse felony punishment facility known as SAFE-P?
No, sir.
And your agreement with the state is to 846 days credit that you have on that case, you understand that a new condition would be that you serve that as a condition of your community supervision, which would mean if you're subsequently revoked by the court, you would not get credit for that jail time on this charge. You understand that?
Yes, sir.
Okay. All right, then the court in CR 22-319 finds that Mr. Castillo has intentionally, knowingly, and voluntarily agreed to the modification of his community supervision conditions. Court will grant the state's motion to withdraw its motion to adjudicate, amends his conditions of community supervision to include safe P and 146 days in the jail as a condition of community supervision. In cause number CR 24-295, upon reviewing the stipulation of evidence, court finds that there is enough evidence to convict the defendant of that offense. Court follows the plea agreement and assesses Mr. Castillo's. Court convicts him of resisting arrest, search, or transport, assesses his punishment at 54 days confinement in the county jail, issues him credit for 54 days of time already served, orders him to pay a $750 fine, $270 court costs, $15 in reimbursement fees, and the court takes into consideration and dismisses unfiled DA 2024-637, failure to ID fugitive, and DA 2024-638, assault causes bodily injury of a family member. In cause number CR 24-296, upon reviewing the evidence, the court also finds sufficient evidence to convict Mr. Castillo of that offense. The court follows the plea agreement, convicts him of evading arrest or detention, a Class A misdemeanor, assesses punishment at 54 days confinement in the county jail, gives him credit for 54 days time of already served. Court orders him to pay $270 court costs and $15 in reimbursement fees. Mr. Castillo, you're hereby remanded to the custody of the probation department and sheriff so they can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted with the deputy. And then I'm sure that you already talked with the probation department about safety and how long that may take for them to pick you up. If not, they'll be able to give you that information. Okay.
Yes, sir. I appreciate it. Thank you.
Anything further, Mr. Trent? You're welcome, Mr. Castillo. Good luck.
No, Your Honor, not in this case.
All right. Thank you, Mr. Castillo.
Thank you. Yeah, Judge, we do have Ms. Wiggins zooming in from the Henderson County Jail. I don't know if they're on yet.
She is. Let me bring them in at this time. Mr. McBride, as soon as we deal with Henderson County in the Zoom, then I will bring in Mr. Rodriguez from Johnson County. They're here waiting.
Oh, okay. I was unaware he was going to be in attendance. That's great.
Yeah, from Johnson County.
Thank you, Judge.
All right, I'm not sure what's taking Henderson County a while, so I'm gonna go ahead and try to bring in Johnson County at the same time so that I can save some time. right, there's Henderson.
Can y'all hear me?
Yes, Mrs. Wiggins, can you see and hear us as well?
Yes, sir, I can.
All right, do you see your attorney, Mr. Schmidt?
Yes, sir. Hi, Brian.
Hey, Katie.
All right, this is cause number CR 15-123, State versus Katie Lynn Wiggins on motion to revoke. Go ahead, Mr. Schmidt.
Your Honor, as the court's aware, Ms. Wiggins has a pending indictment on, in Henderson County. Mr. Mills is appointed to represent her there. That case is set for a status conference on December the 10th. And speaking with the state, we would like to see, with the court's permission, what Henderson County is going to do, because that is going to, number one, affect the state's offer potentially, and certainly affect our position as to whether, you know, how we can resolve this case. Given that she's set December 10th, and it is a first status conference, Judge, I kind of expect that it might be reset for one more status after that. I don't mind setting in December if you wanted, but I think it might be more fruitful to set it for January. And if they get resolved sooner, I can always get an earlier setting from you with your permission, but it's just whatever the court pleases.
Date, any preference?
No preference, Your Honor. I think there's a certain amount of sense to going ahead and giving ourselves more time and requesting an earlier setting if it becomes a.
All right, court will set Ms. Wiggins then another hearing on her motion to adjudicate January 23rd.
Be great.
All right, Ms. Wiggins, if you're still in Henderson County at that time, we'll arrange for you to be Zoomed. If not, if you complete your business in Henderson County, then we'll have you bench warranted over to Van Zandt to take care of your business here, okay?
Yes, sir.
All right, tell the jail staff at Henderson County I appreciate their help today.
Thank you so much.
You're welcome. Have a good day.
Have a happy Thanksgiving.
You as well.
Thank you, Judge. That's all I have. May I be excused?
Yes, thank you, Mr. Schmidt.
Thank you.
Mr. McBride, if you'll bring that microphone right there, just bring it with you and come forward. That way, Mr. Rodriguez will be able to see you better. And he'll kind of stand right here in this little blue square right there. That's probably where he'll see you best. All right, there we go. Mr. Rodriguez, can you see and hear me okay?
Yes, sir.
All right, this is cause number CR 18-503, State versus Josue Rodriguez. This is a hearing on Mr. Rodriguez's motion to adjudicate. And for the record, Mr. Rodriguez is appearing in custody from Johnson County via Zoom. Mr. McBride, any announcements?
Yes, Your Honor. I think we've worked an arrangement with the state on this case. We have a deal. I think it's going to involve has yet to be done, a modified motion to adjudicate. So I've got some technicals in there. I'm just as open as I can be. So I can plead him to a technical and then do a 3-year term and resolve this. So if we could set it for a plea date, and I don't care if that's via Zoom, and I take the paperwork down to Cleburne, you know, that's about an hour from me where I live, so I can do that, or you could bench them up here. Whatever's most convenient to the court.
Mr. Rodriguez, do you know when your next court date is in Johnson County?
January 23rd.
January 23rd. Do you look to resolve his case here in Van Zandt County before January 23rd?
Correct, if we could, up to the court schedule, but yes, we would like to do that.
What I could do, Mr. McBride, is I could set it on December 17th. And that is, it's roughly that's three weeks. And then I'll let you get with the state and y'all can determine whether or not you want to get the plea papers and go to Johnson County and do that. If you're going to want him bench warranted here, then I'm going to need to know as soon as possible so we can make arrangements for jail staff to go and do that for Johnson County to release him.
So it doesn't make any difference to the court if we do it from Johnson and just save the trouble and get it done.
No, so long as Mr. Rodriguez waives the in-person hearing, as long as he's got the paperwork and he has signed it. What's ideal is that you do all of that beforehand. That way the papers can be back here
Yep.
on the 17th. I've got no problem with that.
Okay, very good. Yeah, since people are in jail, it's easier to get them fingerprinted. So remote works.
Okay. All right. Court will set Mr. Rodriguez then on December 17th at 1:30.
Thank you. And brief moment, Josue, I will be down and see you with some paperwork and go over all this. Cool.
Okay.
All right. Thank you, Mr. Rodriguez. Tell the jail staff at Johnson County, I appreciate them hooking you up via Zoom today.
Okay, thank you.
You're welcome. Have a good day, sir.
You too.
Very good. May we be excused,
Yes,
Judge?
thank you, Mr. McBride.
Thank you. Have a happy Thanksgiving.
You as well. All right, Mr. Manning, you ready?
Yes, Judge.
Who are you ready on?
Start with Mr. Hare.
Charles Ray Hare, CR 23154.
Judge, I believe we reached an agreement in this case. We are finalizing the terms of that agreement. If we can get him reset for a plea in the next couple of weeks.
Could you do next Thursday, December 5th?
That works, Judge.
All right, court sets Mr. Hare then for plea on December 5th, 9 a.m. I'm sorry, 1:30 a.m. Take that back. 1:30 p.m. Not
Yes,
9 a.m., not 1:30 a.m., but 1:30 p.m. post meridian.
Thank you, Your Honor.
You're welcome, Mr. Hare. Who's next, Mr. Manning?
Judge, next ready, Miss Cynthia King.
Cynthia Annette King, CR 24-212. Is Ms. King entering a plea today?
She is, Judge.
All right, Ms. King, if you will, ma'am, raise your right hand. I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
All right, you can lower your hand. Just make sure you speak up loudly and clearly so the microphone picks you up so I can hear you. All right, Ms. King, are you a United States citizen who reads, writes, and speaks English?
Yes.
And have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney and the work he's done for you?
Yes.
Do you understand everything that you've read and signed today?
Yes.
Do you have any questions about anything before we go further? All right. Mr. Manning, do you believe Ms. King to be competent?
I do.
And you've explained to her her rights regarding this case, including the advantages and disadvantages of a deferred adjudication plea?
I have, Judge.
And you believe that she's entering into this plea intentionally, knowingly, and voluntarily?
I do believe she's entering into this plea intentionally, knowingly, and voluntarily.
All right, Ms. King, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 1 gram, less than 4 grams. That is a third-degree felony, which does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a possible fine not to exceed $10,000. I see that the state's recommendation is for the court to consider the evidence, and if the court finds that there is enough evidence to convict you of this offense, that the court consider that, but defer a finding of guilt. That means not convict you, but rather to place you on community supervision or probation for 6 years, and also to order a fine of $1,500 plus court costs of $290, reimbursement fees of $520, and also restitution in the amount of $761.62. Is that your understanding of the plea agreement, Ms. King?
And Judge, if I may, there was one thing, when I got here, looking over the paperwork, discussing with Ms. King, I believe that restitution is for medical from the Van Zandt County jail while Ms. King's been in custody. I spoke to the jail staff and they were able to print out that she does not have a balance for that. So all I'd ask is that the court to take evidence or to take that into consideration, and we will provide the documentation we have to the clerk's office to give her credit for the money that she has paid towards those that restitution.
Are you wanting the court to strike that restitution?
Well, Judge, it's on her court cost sheet as being owed. I don't know if they've given her credit for what's been paid at this point in time. Oftentimes when they're on pretrial release and they're paying money towards pretrial release, they don't get that credit until after they've pled. And so my assumption was it would be handled the same way in this situation, that once she's pled, they'll go look at the credit that she's been accrued on her accounts. But I did confirm today that she does have a $0 balance here at the jail. All her medical has been paid. All her expenses have been paid. And so I don't believe there's any need for restitution. I just asked the court to consider that post sentencing if there's any issues.
Okay, so you're saying that it should remain in the judgment, but you have proof that there is no restitution owed, or there was credit applied to it that zeroed out the balance.
That's correct, Judge.
Okay, very well. Anything further from the state?
Nothing further, Your Honor. Thank you.
Okay, all right, Ms. King, understanding the range of punishment, understanding the plea agreement in this case, Ms. King, how do you plead to possession of a controlled substance in penalty group 1 greater than 1 gram, less than 4 grams?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And Ms. King, has anybody threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
All right, stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Just close, Judge.
All right, court will review the evidence. All right, court finds that there is enough evidence to convict the defendant of this offense. The court will follow the plea agreement and recommendation of the DA's office. Court hereby defers a finding of guilt on the 3rd-degree felony offense of possession of a controlled substance in penalty group 1 greater than 1 gram, less than 4 grams. The court defers a finding of guilt, places Ms. King on 6 years community supervision, orders her to pay a $1,500 fine, court cost of $1,500. Fine of $1,500, court costs of $290, reimbursement fees of $520, and restitution in the amount of $761.62. The court has noted on the record that Ms. King may have already paid off her restitution, and we'll let counsel for the defendant submit that to the court. All right, Ms. King, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. After you're fingerprinted, then I'm sure the probation officers will be telling you about what's next. Okay? All right, go ahead and step over to be fingerprinted.
Judge, I believe that concludes my business. Can I be excused?
Yes, sir. Thank you, Mr. Manning.
Thank you, Judge.
All right, Mr. Schmidt, who would you like to start with?
Katie Williams.
No, not sure.
All right, Ms. Williams, this is cause number CR 22-299, State of Texas versus Katie Renee Williams. Ms. Williams, if you'll raise your right hand, I'm going to place you on oath. Ms. Williams, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. All right, is your name Katie Renee Williams?
Yes, sir.
Ms. Williams, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And you're currently on probation in this court, is that correct?
Yes, sir.
It appears that you were in court on March 7th of 2023, and at that time you pled guilty to the state jail felony offense of theft of property greater than $2,500, less than $30,000. The court heard the evidence, found that there was enough evidence to convict you, but the court followed an agreement that you reached with the DA's office, and the court deferred a finding of guilt and placed you on 3 years community supervision and ordered a $1,000 fine. It was during your period of community supervision that the state has filed a motion to adjudicate your guilt. And in that motion, they have alleged what appears to be 8 separate violations. Have you had enough time to review that motion with your attorney, Mr. Schmidt?
Yes, sir.
And do you have any questions of the court or Mr. Schmidt before we go further?
Yes, sir.
You understand everything that you've read and signed today as part of your plea agreement?
Yes, sir.
Mr. Schmidt, do you believe Ms. Williams to be confident?
I do.
And you explained to her rights as they pertain to this case?
Yes,
And does she waive the formal reading of the state's motion?
we do.
And does she intend to plead true to all 8 counts?
Yes, sir.
Okay. All right, Ms. Williams, then, with regards to counts 1 through 8 contained in the state's motion, are those counts true or not true?
True.
And are you telling me that each one of those are true because in fact what's alleged is true?
Yes, sir.
And Ms. Williams, has anybody threatened you, forced you, or pressured you to plead true to anything?
No, sir.
All right, the court will accept the defendant's pleas of true to each count as alleged. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection.
All right, that is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
No, sir.
All right. Then based on the evidence before the court finds that Katie Renee Williams has violated the terms and conditions of her community supervision. The court finds all 8 counts to be true. Court will follow the plea agreement and recommendation of the DA's office here today. The court hereby adjudicates her guilt, convicts her of theft of property greater than $2,500, less than $30,000, a state jail felony. The court revokes her community supervision, assesses her punishment at 6 months confinement in the state jail division of TDC, orders her to pay the balance of her financial obligations, and the court awards her 48 days credit towards her sentence for the time that she's already spent in jail on this case. Ms. Williams, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. We'll have you step over to be fingerprinted. Once you are released from TDC, if you are still owing fine and reimbursement fees, it's important that you report to the Van Zandt County Courthouse, go to the top floor and speak with the district clerk's office and make arrangements to get that paid off. Otherwise, a warrant may issue for your arrest, okay?
Yes, sir.
All right, good luck to you. Step over to be fingerprinted.
Thank you.
Who's next, Mr. Schmidt?
Justin Hall.
This is cause number CR 21-385, State of Texas versus Dustin Lee Hall. Mr. Hall, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. All right, Mr. Hall, you were in this court on July 5th of 2022 on the charge of possession of a controlled substance in penalty group 1, greater than 4 grams, less than 200 grams. On that day, the court heard the evidence from the state and followed their recommendation in your plea agreement. The court found that there was enough evidence to convict you of that offense, but the court deferred a finding of guilt, placed you on community supervision for 5 years, and also ordered you to pay a $1,500 fine. And it was during that period of community supervision that the state had filed this motion to adjudicate and then also amended its motion and filed what appears to be $14 separate counts of violations. Have you had enough time to review the state's amended motion with your attorney, Mr. Schmidt?
Yes, sir.
Are you pleased with Mr. Schmidt as your attorney and the work he's done?
Yes, sir.
Do you have any questions about anything?
No, sir.
Mr. Schmidt, do you believe Mr. Hall to be competent today?
I do.
And you've explained to him his rights as they pertain to this motion to adjudicate?
Yes, sir.
And do you believe that he is entering into this agreement intentionally, knowingly, and voluntarily?
I do.
All right, and does he waive the formal reading of the state's motion to adjudicate, and is he pleading true to all 14 counts?
Judge, we do waive formal reading. He's pleading true to counts 1 through 13. The state has agreed to abandon count 14.
Very well. All right, Mr. Hall. At this time, how do you plead to counts 1 through 13 as contained in the motion? Are those counts true or not true?
They're true.
And the court will note for the record that that count number 14 is abandoned by the state. Is that correct, Mr. Hartwell?
Yes, Your Honor.
All right. And Mr. Hall, you're pleading true to counts 1 through 13 because what the state's alleging is true. Is that correct?
Yes, sir.
And has anybody threatened you, forced you, or pressured you to plead true to anything?
No, sir.
All right. The court will accept the defendant's plea of true. Mr. Schmidt, any objection to his plea of true and waiver being admitted in evidence?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right. I see that the plea agreement today is, and the recommendation is that Mr. Hall's guilt be adjudicated, that his community supervision be revoked, and punishment be assessed at 7 years confinement in the Texas Department of Criminal Justice. Also, with the balance of his financial obligations, including fines, restitution, and reimbursement fees, and that he would receive 393 days credit towards his sentence for the time he's already spent in jail. The court, finding that Mr. Hall has pled true to all 13 counts, the court finds that there's evidence that he has violated the terms and conditions of his community supervision. The court finds all 13 counts, 1 through 13 to be true. The court finds that the state has abandoned count 14. On the basis of that finding, the court hereby follows the plea agreement recommendation of the DA's office. The court hereby adjudicates the guilt of Dustin Lee Hall, convicts him of the second-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 4 grams, less than 200 grams. The court revokes that community supervision, assesses his punishment at 7 years confinement. The Texas Department of Criminal Justice Institutional Division orders him to pay the balance of his financial obligations and awards him 393 days credit towards his sentence for the time that he's already spent in jail on this cause. Mr. Hall, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you are released from TDC, if you've not paid off your financial obligations, then report to the courthouse and ask to make a payment plan, okay?
Yes, sir. Thank you.
All right, you're welcome. Good luck to you, sir. Step over to be fingerprinted. Who's next, Mr. Schmidt?
Lonnie Austin.
This is cause number CR 22-166, State of Texas for Lonnie Travis Austin. Mr. Austin, if you'll raise your right hand, I'm going to place you on your oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, Mr. Austin, you appeared before the court on December 1st of 2022, and you pled guilty to possession of a controlled substance, group 1, greater than 1 gram, less than 4 grams, a third-degree felony. Court heard the evidence that day, found that there was enough evidence to convict you, but the court followed a plea agreement between you and the DA's office, and the court deferred a finding of guilt and placed you on community supervision for 2 years and ordered you to pay a $1,500 fine. It was during your probationary period that the state has filed motions to adjudicate, including up to its 6th amended motion to adjudicate. Have you had an opportunity to review that latest motion with your attorney, Mr. Schmidt?
Yes, sir.
And in that motion, there appears to be 26 allegations of violations. Do you have any questions about that charge or anything else that you signed today?
No, sir.
Mr. Schmidt, well, and let me ask you this, Mr. Austin, are you pleased with Mr. Schmidt as your attorney and the work he's done?
Yes, sir.
Mr. Schmidt, do you believe Mr. Austin to be competent to enter into an agreement?
I do.
And does he waive the formal reading of the state's 6th amended motion to adjudicate?
We waive formal reading, Judge, and Mr. Austin intends to plead true to counts 1 through 20 and count 23. And the state has agreed to abandon counts 21, 22, 24, 25, and 26.
Thank you, Mr. Schmidt. All right. All right, Mr. Austin, I see that the plea agreement today in which you're asking the court to approve is that the court adjudicate your guilt based on your violations, that you be convicted of the offense of possession of a controlled substance between 1 gram and 4 grams, a third-degree felony, that the court revoke your probation, assess your punishment at 2 years confinement in the Texas Department of Criminal Justice, with you being ordered to pay your financial obligations, which at this point appears to only be $50 of reimbursement fees, and that the court dismiss unfiled DA 2024-861 burglary of a habitation, and also a theft of property between $100 and $750. That being DA 2024-713. And that you would receive towards your sentence your jail time credit of 135 days. Is that what you're asking the court to approve, Mr. Austin?
Yes, sir.
All right, Mr. Austin, understanding the plea agreement then I'm going to ask you at this time, how do you plead to counts 1 through 20 and also count 23?
True.
And are you pleading true to counts 1 through 20 and also count 3 because what is alleged is in fact true?
Yes, sir.
All right. And Mr. Austin, has anybody threatened or otherwise pressured you to plead true to anything today?
No, sir.
All right, then the court will accept the defendant's pleas are true at this time. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights and plea of truth?
No, sir.
That is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state?
Nothing further, Your Honor. Thank you.
Anything further from defense?
No, sir.
All right, then based on the evidence before the court finds that Monty Travis Austin has violated the terms and conditions of his community supervision. Court will follow the plea agreement and recommendation of the DA's office. The court finds counts 1 through 20 and also count 23 to be true. Court finds the state has abandoned counts 21, 22, 24, 25, and 26. The court hereby adjudicates Mr. Austin, convicts him of the underlying offense, revokes his community supervision, assesses his punishment at 2 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, and dismisses under Section 1245 DA 2024-861, burglary of habitation, and DA 2024-713, theft of property between $100 and $750. Court awards Mr. Austin jail time credit of 135 days. Mr. Austin, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted.
Thank you, Judge.
You're welcome. Who's next?
Miguel Hernandez Marquez.
All right, this is cause number CR 18-366, State of Texas versus Miguel A. Hernandez Marquez. Mr. Hernandez, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your hand. All right, Mr. Hernandez, you were before the court on February 26 of 2019. You pled guilty to driving while intoxicated with a child passenger under 15 years of age, a state jail felony. Court heard the evidence, but the court followed the plea agreement and recommendation of the DA's office. The court convicted you of that offense and assessed your punishment at 2 years confinement in the state jail division of TDC and ordered you to pay a $500 fine. On that day, the court also suspended that sentence and placed you on community supervision for 3 years. It was during your probation period that the state filed its motion to revoke your community supervision. And in that motion, they alleged 7 different violations of your probation. Have you had enough time to review their allegations with your attorney, Mr. Schmidt?
Yes, sir.
And do you have any questions about anything, including the paperwork you signed today?
No, sir.
All right, Mr. Schmidt, does Mr. Hernandez waive the formal reading of the motion to revoke, and is he pleading true to all 7 counts?
Yes to both.
All right. And I'm not sure if I asked you, but do you believe Mr. Hernandez to be competent to enter into this agreement?
I do.
All right. All right, I see here that there's a plea agreement. So based on the evidence before the court finds that Miguel A. Hernandez Marquez has violated the terms and conditions of his community supervision. The court finds all 7 counts alleged to be true. And the court follows the recommendation today. The court revokes his community supervision, assesses punishment at 8 months confinement in the state jail division of TDC, orders him to pay the balance of his financial obligations, and awards him a jail time credit of 99 days. Mr. Hernandez, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of this sentence. Good luck to you, sir. Who's next?
This is Dallas Hightower.
File number CR 23-217, State versus Dallas, Justin Hightower. Is this a plea today?
It is not, Judge, but we're gonna ask the court set Mr. Hightower for a plea on your next contested evidentiary docket.
Just so I'm clear, why did we not plea him today?
Judge, up until yesterday, I think it was the consensus of everyone involved that Mr. Hightower would have benefited from inpatient rehabilitation for substance abuse issues due to the nature of the charge. SAFE will not accept him, and we ran out of alternatives. And so what I have to do is I have to go back to the DA's office, and we have to come at it from a different angle. I don't see that inpatient rehab is going to be an option, and that was finalized as of yesterday. So that's why it's not a plea.
Okay. My next evidentiary is not until the end of January.
I understand, Judge, and if it's okay with the court, obviously, if I can get something, I'd ask the court to add him earlier, but I think that'll give us plenty of time.
All right, court sets Mr. Hightower for contested hearing on the evidentiary docket, January 23rd, 2025 at 1:30.
Robert Wales, I believe, is in the courtroom, and Mr. Hagel's here for arraignment. You want to do
Yes.
Mr. Hagel first?
Yes, please. Do you have that indictment?
I do have it.
Okay. All right, this is cause number CR 24-232, State versus Michael Tanner Hagel. We're set for arraignment today. Go ahead, Mr. Schmidt.
Judge, I've got a copy of the indictment. Mr. Hagel's name is spelled correctly in the indictment. We'll waive formal reading, enter a plea of not guilty, and ask for a pretrial setting.
All right, court finds that Mr. Hagel, having waived the formal requirements of arraignment, enters his plea of not guilty into the record, sets this matter for pretrial hearing. How are you on January 7th, Mr. Schmidt?
That should be fine.
All right, court sets Mr. Hagel then for pretrial hearing January 7th at 1:30. Mr. Wells, come on up. Come on around the podium. You'll come right up here to the front. This is cause number CR 17-266, State of Texas versus Robert Michael Wales. We're set for evidentiary hearing today. Go ahead, Mr. Schmidt.
Judge, we've been carrying Mr. Wells on motion, the state's motion, for a little while for compliance. At this point in time, I think we've reached an agreement with the state to resolve his business. It's going to require a TDC sentence. We'd ask to set him for a plea.
How much time do you need, Mr. Schmidt?
I guess for the sake of compassion, perhaps after the first docket after the holidays would be wonderful if we could get that from the court.
Are you talking about Thanksgiving, or are you talking about Thanksgiving and Christmas?
Thanksgiving and Christmas.
Any objection from the state?
No objection, Your Honor.
All right, then the court will set Mr. Wells for plea on January 7th. And that'll be at 1:30. And so Mr. Wells, Mr. Hernandez is, Mr. Martinez is filling out this notice of appearance for you. And so you're going to sign this. We're going to give you a yellow copy. It says you're going to be back on January 7th. 1:30. 1:30. It'll be an afternoon plea. And so on that day, Mr. Wells, I want you to just report out to the jail because it'll be out there. Okay.
Go straight there?
Yeah, go straight there, and then they'll bring you in the back, and Mr. Schmidt will be there. Okay. All right, so you're free to go. Yeah. If you have questions, then Mr. Schmidt will be able to talk to you. You probably don't want to ask any questions right now, but
Just shoot me an email and I'll respond.
I did shoot you an email.
Okay, I haven't had a chance, but I will. Okay.
Well, if you look at your email, then this isn't needed.
Well, no, you need to just go ahead and step out of the courtroom and I'll
Okay.
contact you.
Sorry, Your Honor.
It's okay. All right, does that conclude the business at the jail?
Yes, Your Honor.
All right. Mr. Lowe, Mr. Gerard, y'all come on up. We're just gonna stand in recess for just a few minutes. I'm gonna gather some things, but come on up, have a seat. All right, we are on record in cause number CR 22-67, State versus Robert Gerard. And I believe that we're here today on an agreement between the state and defense for the court to conduct a bench trial on the issue of sanity. Is that correct?
Yes, Judge, a bench trial on all issues. It requires the court to make a finding that the offense did occur beyond a reasonable doubt, and then a finding that the defense has proved by a preponderance that he was insane at the time of the offense. But I think both issues are agreed to between the parties, Judge, and we've also executed a waiver of jury trial.
All right. And before I consider the waiver of jury trial, I also want to go ahead and discuss Mr. Gerard's competency. I'm not sure that we've formally announced that on the record since his last finding of competency. Mr. Lowe, your client was evaluated for purposes of competency. You were given that report and you had no objection to it at that time. Is that correct?
That's correct, Your Honor. And if the court would like, I have a copy of the report. We can mark its exhibit for this hearing, or we need to have do that.
Yeah, I think that'd be great.
I've got it marked as exhibit 2.
No, no objection.
All right, then defendant's exhibit 2 is admitted. Court finds that Mr. Gerard has been found competent to stand trial, that with the assistance of counsel has not objected to said finding, and neither has the state. All right. So with the issue of sanity, we'll go ahead and proceed. And Mr. Lowe, I believe that it was your motion. However, I think the burden is still on the state. Is that correct?
First burden is on the state. Judge, did you want to take up the waiver of jury trial?
Oh, yes, I'm sorry. All right, the court finds that Robert Calvin Gerard III has waived his right to a jury trial by submitting a written waiver of jury trial. Mr. Gerard, you'll raise your right hand, sir. I'm going to place you under oath. Mr. Gerard, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your hand. Mr. Gerard, in this case, you've been represented by different attorneys, but at this time you're represented by Mr. Lowe as your criminal defense attorney. Is that correct?
Yes, sir.
And you and Mr. Lowe have had several discussions regarding your case. Is that correct?
Yes, sir.
And one of those discussions centered around whether or not you wanted to waive your right to a jury trial. Is that also correct?
Yes.
And Ms. Curry has handed to the court a document called waiver of jury trial, and it appears to bear your signature. Did you discuss what it means to waive your right to a jury trial with your attorney, Mr. Lowe?
Yes.
And do you understand that, Mr. Gerard, you and only you can waive that right? Mr. Lowe can't waive it. Ms. Curry can't waive it for you. I can't even waive it for you. You and only you can waive your right to a jury trial. You understand that?
Yes, sir.
And if you do waive your right to a jury trial and the court accepts it, that means that you would not get an opportunity to cross-examine the state's witnesses or any of their evidence in front of a jury. You understand that?
Yes, sir.
And once you waive it, it's something that you won't be able to have restored to you at a later date if you change your mind. Do you understand that?
Yes, sir.
And so you've talked about the advantages and disadvantages of waiving your right to a jury trial in this matter. Is that correct?
Yes, sir.
And today you're telling me that you want to waive your right to a jury trial, that you've talked with your attorney, Mr. Lowe, about it, that you fully understand what your rights are and what you're waiving here today.
Yes, sir.
Mr. Lowe, as counsel for Mr. Gerard, do you join him in waiving his right to a jury trial?
Yes, Your Honor.
And you believe that he's competent today and that he's entering into this waiver intentionally, knowingly, and voluntarily?
I do.
All right, then the court finds that Robert Calvin Gerard III has intentionally, knowingly, and voluntarily waived his right to a jury trial, that he's had the assistance of counsel. Counsel has joined him. Court also finds that the DA's office has also waived its right to a jury trial by signature of the DA. Court hereby approves the waiver of jury trial. Ms. Curry, you ready to proceed?
We are, Your Honor.
You may.
Thank you, Judge. Judge, would the court like us to read the indictment at this time?
Yes, please.
Clause number CR 22-00067, State of Texas versus Robert Garrard. In the name and by the authority of the state of Texas, the grand jury for the county of Van Zant, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January term AD 2022 of the 294th Judicial District Court for said county, upon their oaths present in and to said court at said term, that Robert Garrard, hereinafter styled defendant, on or about October 22nd, 2021, and before the presentment of this indictment in the county and state aforesaid, did then and there intentionally and knowingly cause the death of an individual, namely William Love, Jr., by shooting him with a firearm. And it is further presented that prior to the commission of the charged offense on the 15th day of December 2016, in cause number CR 10-00129, in the 294th Judicial District Court of Van Zant County, Texas, the defendant was finally convicted of the felony offense of possession of a controlled substance, penalty group 1, greater than 4 but less than 200 grams, against the peace and dignity of the state, signed by the foreperson of the grand jury.
All right, thank you, Ms. Curry. And at this time, does the defense enter a plea? Does the defense?
Yes, Your Honor. You ready?
Not guilty by reason of felony.
Thank you, sir. You may be seated.
Thank you, Your Honor.
Ms. Curry.
Thank you, Judge. Your Honor, at this time, by agreement and stipulation, we offer States Exhibits 1, 2, and 3. States Exhibit 1 and 2 are offense reports concerning the offense charged in the indictment in this case, and States Exhibit number 3 is the autopsy report of the victim in this case.
We'll stipulate no objection.
Thank you, Mr. Lowe. All right, no objection and stipulation being tendered. Court hereby admits States Exhibits 1, 2, and 3 respectively.
Your Honor, we believe those exhibits are sufficient to establish beyond a reasonable doubt that this defendant did in fact cause the death of William Love Jr. by shooting him with a firearm. The court will also know as it reviews those exhibits that particularly in Exhibit 2, I believe page 4, maybe page 5, there are some statements regarding Mr. Garrard's mental health at the time of the shooting. And with that, Your Honor, the state rests for purposes of guilt innocence.
Mr. Lowe.
Yes, Your Honor. And it will call Dr. Susanna Lampley, MD.
Dr. Lampley.
Closer. Maybe it's closer.
Yeah, as long as you put it out there in front of you, it'll. Good afternoon. You'll raise your right hand. Now, do you swear that the testimony you give before today is the truth, the whole truth, and nothing but the truth? So I see that chair move, so move it around. During your testimony, it's important that you just speak up loudly and clearly. You don't have to lean into the microphone. I'm sure that you've probably testified in court before, correct?
Yes,
All right, so if you'll do me a favor and make sure that you allow the attorneys to finish their questions and statements before you give the answers, so we're not talking at the same time, okay?
will do.
Mr. Lowe, you're with us.
Thank you, Your Honor. Tell us your full name, please,
Susanna Fair Lampley.
and how you employ Dr. Lampley.
I am a forensic psychiatrist at Terrell State Hospital.
All right, Your Honor, if I could approach the witness.
Okay, yes, sir. And both counsel can approach the witness without seeking permission.
Thank you, Your Honor. Dr. Lampley, let me hand you what I've got marked as defendant's exhibit number 1. Could you identify that, please, for us?
This is a copy of my resume.
Right, and does it state your educational background, work experiences, articles, and things like that?
Yes, it does.
We'll offer number 1, Your Honor.
No objection, Judge.
All right, then defendant's exhibit number 1, defendant's exhibit number 1 is admitted without objection.
Do you have another copy? Did you look at it?
I have another copy,
Okay.
thank you.
Thank you, Your Honor. And the counsel for the state has reviewed it. So let me give you kind of a quick thumbnail sketch what I'd like to cover this afternoon. So I'd want to talk about your qualifications first, And then I'm going to talk to you about ask you questions about the law of insanity in the state of Texas. And then I'll ask you for a brief statement as to your opinion under the law, and then we'll go through your report. And then we'll be talking about, I want to discuss some issues of malingering possibility that you would have outlined in your report, the issue of dangerousness, the use of methamphetamine as it relates to this offense, and then what happens next after the court, if the court finds that he's not guilty by reason of insanity. So if we could do that. So let's talk about your qualifications first. Can you describe your work history for us, please?
Yes, well, after high school, I graduated and then joined the military. Decided after that to go to medical school. So I went to the Texas Tech in El Paso and graduated medical school there in 2012. And then afterwards, I joined the team at UT Southwestern in a general psychiatry residency, which I graduated from in June of 2020. And then I'm board certified as of September 14, 2020. I went on to then do a fellowship in forensic psychiatry, and I'm board certified in forensic psychiatry as well as of October 23, 2023.
So I noticed that you did serve in Iraq.
Yes.
In the military.
Yes.
And I think everybody here appreciates your service on that behalf. So thank you very much. So your educational background, can we discuss that, please?
Yes.
And so that's stated in your resume. So what are your job duties now? And you said you work for the state hospital. What are your job duties now?
So I take care of patients who have been adjudicated not guilty by reason of insanity, as well as patients who have been found incompetent to stand trial. I also take care of acute patients that aren't forensically related, just as routine inpatient psychiatry. So I do a bit of both, and I work on the forensic unit at Terrell State Hospital.
All right. And so the law, chapter 46C requires that you be able to render these opinions. Do your qualifications allow you to do that in a case such as this?
Yes, they do.
All right. So anything else we need to discuss about your qualifications that's relevant to this at this point?
I don't think so.
Your Honor, I'd move the court to accept her qualifications under chapter 46.
Any objections?
No, Your Honor.
All right, then, based on the testimony of Dr. Lansley, the court finds that she is qualified to render an opinion on the issue of sanity as provided by Article 46C.
Thank you, Your Honor. All right, so let's talk then. Can you give us an outline of the requirements for a verdict and a finding of not guilty by reason of insanity as it relates to your job as a psychiatrist?
Yes, so in order to meet the test in Texas, that individual would have to have a severe mental disease or defect at the time of the crime that interfered with their understanding of the wrongfulness of the act.
All right, so before you work at Terrell, obviously, have you met, before this case happened, did you have any chance to know Robert or meet with him or treat him in any way?
Before this case, no.
All right, and so did I ask you to give an opinion in this case as to whether or not he would meet those tests required by the statute?
Yes, you did.
All right, and could you briefly state your opinion as to whether or not he meets that two-pronged test for not guilty by reason of insanity?
Yes, I did think Mr. Gerard met the test because at the time of the offense, he was experiencing symptoms that were consistent with what an individual with psychosis would be experiencing, such as delusional beliefs, paranoia, auditory hallucinations, and those were present at the time from the evidence that I saw. And then in addition to that, I had to look at whether or not this was the influence of a substance itself, because if that were the case, then he wouldn't meet the criteria if he was acutely intoxicated on methamphetamines. And then I found there was evidence to support that he wasn't acutely intoxicated at the time, as I was able to view videos of him after the offense, view the police interview, and then also review prior records of what he looked like when on methamphetamines, when even off them, whether he still had symptoms of mental illness. And then in addition to that, I interviewed him on 2 separate occasions, met with him, asked him questions related to the offense to get his version, and I did come to the finding that he met the test for, in my opinion, that he was insane at the time of the offense.
Thank you. Lampley, I'm now showing you what I've marked as in this exhibit number 3. And can you identify what that is, please?
This is a copy of the sanity evaluation that I sent to you after I completed my report,
All right, and how many pages does it have?
including the cover pages. It should be 25. The actual sanity evaluation was 21.
And that's a true correct copy of your original document.
Yes, it is.
Your Honor, we'll offer this time defendant's exhibit number 3.
No objection, Judge.
There being no objection, defendants 3 is admitted.
Okay, so you have a copy of your report. You can pull it out, please. Ready?
Yes.
All right, so I'm looking at page number 1 of your report. You start with sources of information, and it looks like there are 20 items that you were able to review.
Correct.
All right, and so on the bottom of the page, number 2, you talk about procedures of the examination. Can you tell us, I think you met with Robert 2 times.
Yes.
Can you describe what you did within the course of that examination?
So when I first met with Mr. Gerard, I performed a clinical assessment of an inventory of his psychiatric symptoms, a complete mental status exam, and then on the follow-up meeting in September 12th, 2024, I performed a sanity evaluation as well as a mental status examination.
And approximately how long did those two interviews take?
About 2 hours each.
And they took place at the Van Zandt County Jail, is that correct?
Yes.
So then continuing on to page 3, you were able to review the offense reports.
Yes.
And it's quite a bit of material, but were you able to glean, there was information in there that would assist you in your opinion as to whether or not he was insane at the time of this offense?
Yes.
All right, so, and then the next section, and I think is really relevant, is the videotaped interview, and then also the in-car, the body cam and the in-car video. So first, let's talk about the information from the videotape interview.
Okay.
And that was with the lead officer, I believe. What was significant to you in the context of that interview?
So what I thought was significant about this interview is that Mr. Gerard was talking about his delusional beliefs, that he could record his thoughts on an EEG board, that he had a helmet that would help him to record his thoughts, that he could try to prove this was all real. He talked about this in depth. He also talked about information that oftentimes people with mental illness have, but if they were if they're truly experiencing symptoms of mental illness, they would report, but someone who maybe just trying to act as if they had a mental illness might not necessarily report. A lot of those were related to sexual experiences, psychotic ones that were significant, and I thought were in line with a person who truly had a significant mental illness. Also, he's very forthcoming. He answers questions directly. He actually tries to convince the interviewer to go to his home and get the equipment because all of the information is recorded on there. That's that's his belief. And those are all consistent with someone who's experiencing delusional beliefs.
All right, and so let me read you just a portion of your report on page 4, and I think it goes to the wrongfulness, whether or not somebody recognizes that they're, whether or not it was wrong for them to commit the act. You say at the bottom of the third paragraph, Mr. Gerard reported he felt he'd acted too quickly and said, "I know I was wrong. Well, I don't think I was wrong. I really think he was talking to me in my head." And Mr. Gerard said several times that he felt paranoid, especially since Mr. Love had shown up out of nowhere. And what is significant about that?
So what's significant is it goes to the question of wrongfulness. So at one point he's saying, well, I know it was wrong. Well, not wrong, but I did it too quick. So indicating what he was thinking at the time of the offense as far as the wrongfulness of it. Then I also looked at the video footage of him in the patrol car where he actually talks about being right. He says, I know I was right. And so that's important information and information that I want to be able to address with Mr. Gerard when I do the sanity evaluation.
All right, so let's talk about the body cam in the patrol car footage. That's striking the way he was acting. Can you just kind of describe his overall demeanor?
So his overall demeanor whenever he's speaking with the officers, he's cooperative, he answers their questions. He doesn't try to hide information, mislead. He's very direct. When the officers leave and he's alone in the car, he's talking to himself. He is speaking in a disorganized fashion. He talks about the event itself, what his thoughts were at the time. And so all of that is important.
And so let me just read you one quote in the second paragraph. Once Mr. Gerard was alone, he muttered and talked to himself. Mr. Gerard was frequently responding to an internal stimuli. What do you mean by that?
So meaning that he's hearing something that those around him would not be. And so either talking to himself, eyes darting around, looking suspicious. And so he exhibits that sort of behavior, but he doesn't try to play it up. When the officers show up, he doesn't try to exaggerate those symptoms that he's experiencing. He actually seems to try to hide them, which an individual who were malingering wouldn't be doing.
Right. And so you mentioned the word malingering. Can you give us what the kind of a layperson's definition and what you mean by that?
Sure, it would be faking symptoms or exaggerating symptoms that were present, but to a much larger degree than what they were truly experiencing.
All right, and then continuing on with that same sentence or that same paragraph, he can be heard saying, "He shot me in my legs." Well, Mr. Gerard obviously wasn't shot in the legs.
Yes. However, Mr. Gerard did have the perceptual experience that he was being shot with a satellite beam by Mr. Love, and that this would cause him to lose consciousness.
Okay. And then skipping on down, apparently he was with the police and then he was alone again. And you say, Mr. Gerard, when alone again, starts talking to himself in a disorganized fashion. What does that mean?
It means his thinking is scattered. It's not linear necessarily, at times illogical, a bit all over the place.
Okay. And then it said, and you say, he could be heard saying, "That guy was crazy though, you know, you seen that show. It's weird that what he was going to do, then the F word, that's smart. I would have shot him too." It sounds like he's having a conversation with somebody that's not there.
Yes, and he did actually describe several individuals he was talking to that were not present. He named a few different names of individuals he was conversing with.
Okay. And then lastly, in that section, he says, "This is Robert talking. Robert, you did a wonderful thing. I gotta put you in jail for murder. That's all right. I didn't do nothing, but that guy is an asshole. he can't talk to us now. And then when the officers return, Robert stopped.
Right,
So just a continuation, he's actually having some conversation with somebody he thinks is either there or he's relating to.
right.
All right, so then, and then you interviewed Robert again, for the second time on September 12th of 24. And you spent some time talking about the offense.
Yes.
What was significant about that conversation on September 12th that you gleaned that would help you in your opinion?
A lot of it, I think a lot of that conversation was significant and was a 2-hour conversation. But what I appreciated was his forthcomingness. He didn't deflect questions. He answered directly. He would provide a lot of information. He didn't try to deflect or take away from or gives information that might make him look less culpable. He also gave a lot of information that he didn't necessarily need to offer, but he did seem to want to participate fully and be cooperative.
All right, so we had the interview in April, and then by September, he had been to Mount Vernon and his competency restored according to their report. Were you able to see a difference in the way he was acting in those two, and you could describe it?
Yes, during the initial evaluation, Mr. Gerard had a flat affect, meaning there's no emotion playing on his face. And that is very indicative of an individual experiencing psychosis. And it's also something that people don't know how to fake. It would be very hard to reproduce. Also, another symptom that people don't know to fake if they're just doing what they see on a movie, that sort of thing, is ideas of reference. So putting together information that shouldn't, like A wouldn't link to B, but in their mind it does. So for example, him describing that there would be a glitch in his phone, this being evidence that he was being tracked and monitored by various legal entities. We wouldn't assume just because our phone had a little glitch in it that were the case, but that is a belief that Mr. Gerard had.
All right, and so you use the word psychosis. I assume that's a word of art. What does that diagnosis mean?
So what I mean by that is delusional beliefs and or perceptual disturbances, like hearing things, seeing things that others aren't, having somatic experiences that aren't actually happening. So for example, sometimes people can believe they're being sexually assaulted in some way, but they're having some sort of physiological response in their body that they then believe is because of something like that when it isn't. It can also be a hallucinatory experience.
All right. And did you, at that point in time, once again, delve in the topic of the wrongfulness of his conduct, whether or not he appreciated that?
Yes, I did.
And tell us about that, please.
So when I asked him about this, he said he thought he would be in trouble because he was a felon with a gun. So he knew he shouldn't have a gun. But when I asked if he were surprised that he was charged with murder, he said, yes, I acted in self-defense.
All right. So you've seen the autopsy. I think self-defense may be a hard road to hoe on a case like this, but so he didn't appreciate the wrongfulness of his conduct, basically where you were.
No, I think he psychotically believed that he was acting in self-defense.
Okay. And once again, you don't think that there was indications that he was malingering or faking symptoms in the course of that interview with you had him on September 12th?
No. And when going back to the patrol car video, he actually says, Robert, there was a sword in there. Why didn't you hit him with a sword? And he says, I didn't think I was fast enough or strong enough. So really goes to the fact how scared he was and thinking that he was going to be killed. Also, he provided information that someone who's trying to deflect culpability on themselves wouldn't offer, such as he didn't actually know how many times he fired. he said he was so scared, he just kept pulling the trigger. And when it was empty, he ran to the other room looking for another clip because he was still so terrified, not recognizing that Mr. Love didn't pose a threat at that point. He was still so terrified that he was going to be killed. And it was only when he heard Mr. Love's raspy breathing that stopped him. He went back to check on him. Then he realized his cousin needed help, and he immediately ran to try to get him help.
And I think the autopsy indicates that there were more than 10, maybe not 10 bullets, but 10 different wounds. It may be like 14, I think, but it was multiple
Right.
wounds. All right. So anything else that we need to discuss about that interview on the 12th that'd be relevant?
Oh, I did ask him, since in the police interview, they asked him about Mr. Love being asleep. He was very adamant that Mr. Love was awake. And I thought that was important as well, because it's something that he's consistently said. So I was looking to it, what he's reported in the past, what he's reporting now. Are those comments consistent with what he's trying to say? And I did think that that was the case.
So Mr. Love was Robert's cousin,
Yes.
and they'd had a history together. Is that right?
Yes, they had grown up together. He said growing up, they were like brothers.
And then, according to Robert, Mr. Love went to prison for a pretty serious offense, was in prison for 14 or 15 years.
Yes.
What do you think that created in Robert as far as an appreciation of a possible danger that Delwyn posed?
Yes, so he talked about the two of them sitting on the couch talking about Mr. Love's experience in prison, and that Mr. Love had been bragging about doing hits for the cartel, that he had killed someone in prison, that he could make a shank out of anything. So I thought that that was important because it likely amped up the underlying paranoia Mr. Gerard already had.
All right. So then I'm going to page number 8 of your report. So I think it's pretty striking that what do you understand happened right after this incident with regard to Robert calling the 911? What's your understanding?
So what he told me is that he immediately ran to his uncle's house. He was still barefoot, and he was so rattled, he actually used his phone as a flashlight, not recognizing that he could have used his own phone to call for help until he got there. So goes to show the sympathetic response, the fearfulness he would have felt at that point, not thinking clearly, logically, that sort of thing.
All right. So let's move on into his psychiatric treatment since the incident. So Dr. Gorman had started, this is not the first time Dr. Gorman had treated Corman, but can you describe to us what the psychiatric treatment was post his arrest or post February 9th of 2023?
Yes, so he was seen numerous times by Dr. Corman while he was in Van Zandt County Jail. On February 9th, 2023, he was still voicing delusional beliefs. He thought he was being harassed by an official with the Van Zandt County Sheriff's Department who he thought was electronically monitoring him. This was a long-standing delusion he'd had already. He thought they were transmitting messages to his head and spoke to him through this EEG helmet. He was then refusing antipsychotic medication. He was court ordered to receive those. And once he started receiving treatment with Zyprexa, on the follow-up visit on the 14th of February, Dr. Corman still described Mr. Gerard as believing that people could hear his thoughts and transmit messages to his head. He talked about his EEG board and the helmet that he had, which were protective for him in his mind for these intrusions. He thought the KKK was harassing him and threatening to rape his mother, his daughter, his sister, nieces. he was reporting auditory hallucinations along with the paranoid beliefs, and he was diagnosed with schizoaffective disorder, bipolar type. Then in the follow-up visits, his symptoms do improve. He's less agitated, aggressive once he's on those antipsychotic treatments, but he is still reporting intermittent auditory hallucinations. And then he had additional agents added to his regimen. I think he actually developed diabetic ketoacidosis and was transferred to Mother Francis in Tyler. Then on his return, treated with Geodon and then sent to North Texas State Hospital, Vernon campus for competency restoration.
All right. So, Your Honor, the court will call that you had to have enter an order with forced medication. I think that's part of the court's record. We ask you to take notice of that at this point in time as well.
Court will take judicial notice of all filings in this case.
Thank you, Your Honor. And so let me read you something I'd like to have liberal explanation about. This is in the second paragraph of your psychiatric treatment paragraph. It says, Mr. Gerard was seen by Dr. Corman February 14, 2023. Dr. Corman described Mr. Gerard as having floridly psychotic symptomology and mood disturbance with mania much of the time for about 10 years now. So what do you mean? What does he mean by that?
So Dr. Corman, in reviewing the medical records that I received in this case, had been treating Mr. Gerard from as early as October 22nd, 2013. And even at that time, years before the offense, he was described as having symptoms consistent with bipolar disorder, manic with psychotic features by Dr. Corman.
And those records, you were able to see those records from the Andrews Center where Dr. Corman treated him for those problems?
Yes, I was.
All right. So then let's talk a little bit about Robert's psychiatric history. This has been a long-standing problem with him.
Yes.
Can you describe that for us, please?
Yes. So like many individuals, Mr. Gerard's symptoms become much more prominent in his early 20s. He initially has symptoms, even before that, he had symptoms of depression, which is not uncommon for individuals with bipolar illness. Then in his 20s, he starts to develop mania. He would so symptoms of mania would be a lot of energy, don't need to sleep a lot. You start to do reckless things. You may be very talkative, speak too rapidly. Your thoughts may come in really fast. And symptoms that Mr. Gerard was reported to have by Dr. Corman back in 2013 were things like he would pick up complete strangers at Walmart and cook for them. He would be up for days at a time, not needing any sleep. He would be intensely irritable, also having periods of depression, as well as manic episodes where he wouldn't need to sleep a lot and have the intense energy.
All right. So Dr. Corman in his record says that describes that he had experiencing auditory hallucinations beginning when he was about 30 years old. Looking at Dr. Corman's records, did you glean any thought that Dr. Corman thought that there was malingering or any faking of symptoms?
No, I didn't get that impression.
All right. And so let me skip on a little bit further. And then the paragraph that says past psychiatric treatment records. I'm looking at that paragraph.
What page are you on?
On page number 11, Your Honor. That indicates that Dr. Corman was treating him since 2013, 9 years or so before this happened.
Correct.
All right. And then in the middle paragraph, Dr. Corman says that he has confirmed bipolar diagnosis. Now, can you explain to us? We've used psychosis, other terms that are related to your profession. What is bipolar disorder? What is that?
So looking at Dr. Corman's notes, there were times when Mr. Gerard was also using stimulants. So the thing about using stimulants is you can look like you have bipolar illness, or you can even experience psychosis because of an effect of that stimulant. So Dr. Corman, his notes reflect that he's looking for this, but he's able to diagnose the primary mood psychotic illness. Those symptoms are present even when Mr. Gerard is sober, which we would not expect if it were purely substance induced. And so
Go ahead.
that he could confirm this diagnosis.
And so we really hadn't talked too much about that, but Robert doesn't have a history with drug abuse,
Yes,
whether it's for self-medication or for whatever purpose, it's documented.
yes,
And so I guess where you're going is that you're distinguishing between the drug abuse and psychosis or bipolar disorder that's not related to either not related or enhanced by the drug abuse. Is that correct?
correct.
And what do you mean by that?
So if an individual were only experiencing symptoms that look like mania, psychosis because of that stimulant, then we would expect when that stimulant wears off, they don't exhibit those features anymore. But Mr. Gerard is still exhibiting those features even when he's sober. And a lot of the notes that Dr. Corman writes when he's in Van Zandt County Jail, where he does not have access to a stimulant, he is still exhibiting these symptoms.
And that happened more than once, according to the records. He'd
Correct.
be in jail or off any sort of illegal substance and still be having the symptoms.
Yes, there was actually a note years before the offense when Dr. Corman described Mr. Gerard as having been in the Van Zandt County Jail for 40 days, and he was still having these symptoms, so that he would not have had access to a stimulant at that point. So we would not expect after 40 days an individual to still be exhibiting features of acute intoxication from a stimulant.
All right. And so I think we've talked about medical histories in the sort of recent past. What did you find out about his medical history that was relevant to your opinion? And I'm looking at page number 13. Past medical history.
So not much there, although anytime someone has a head injury, that's important. And so he did seem to have a really significant head injury when he was 21, where he fell off a trailer and then the trailer ran over him, which he had gone to the emergency department for, but I don't think there was any head imaging at that point. But those are things that we take notice of.
So it's not, you're really not able to say that there was a relationship between his psychosis now and that head injury, but we just don't know from the records what happened.
Right. So I'm just documenting medically what his past history is. And anytime somebody's had a head injury, seizures, or other medical illness, we just want to know, that way we can make sure there isn't a medical reason they may be having these symptoms. So we rule out a condition that might have been induced by a general medical condition.
Okay. So then what medications is he currently taking? I'm looking at page number 13.
So Seroquel. That would be the antipsychotic he's currently being treated with. And from my understanding, when he was treated with Zyprexa, he actually developed diabetic ketoacidosis. So Zyprexa is a medication that can cause significant metabolic disturbance. You can develop diabetes from that medication. And from my reading of the record, I believe that's what happened with Mr. Gerard, which is why he was taken off of it.
All right. So continuing with substance abuse history, looks like he reported to you that he'd been smoking marijuana as a teenager and that graduated to methamphetamine.
Yes, he told me that in college he started to have difficulty concentrating. He initially tried to obtain Adderall, which was beneficial for him, but when he couldn't obtain it, then he was introduced to stimulants, and that quickly became the drug of choice.
And so is that something that reluctantly we see quite a bit of, is people self-medicating with when they can't get the drugs that they need?
It's very common, yes.
All right. And so then I think you had a chance to talk, to get his social history. Can you describe for us what his social history is or was? I'm sorry.
So Mr. Gerard reported a pretty uneventful childhood. He was raised by his biological mother, had a brother and sister. He described having a good childhood. He was actually a gifted student, had an above average IQ, did well in school, was well liked by his peers. His mother reported to me that he was prom king, the life of family gatherings, so an individual that others quickly related to, liked, and there wasn't anything in that childhood history that would be suggestive of someone who had was developing antisocial tendencies or traits.
Okay. And I think he was able to hold employment at Tyler Pipe for a while until his psychosis.
Yes, so apparently he wore a headset at that job, and so in the headset, you know, you're hearing other people speaking, but then he started to hear those voices even when he took the headset off, and it became so distressing for him. He couldn't function while at work, so apparently they very much liked him at that job, but they had to let him go as they felt that they weren't able to safely still employ him. And then he was rewarded disability benefits for his mental illness after that.
All right. And you mentioned that you were able to talk to Ms. Gerard, his mother. What did you glean from her that was relevant?
So Ms. Gerard described Robert as a happy kid, always laughing, helpful, that he was outgoing, seemed like an average, normal teenager, but then he had a head injury in his 20s and he started to be a little bit more withdrawn, isolative. This is also the time period when Mr. Gerard reported to me he first began having symptoms of mental illness, and like many people, he didn't immediately seek assistance for those symptoms, and then that gradually worsened to the point where he started to hear voices. At that time, they were living together, and he would question her, asking her, don't you hear them too? Believe that she weren't being truthful with him, that she could hear them too. She described him as wrapping tin foil around his body to try to keep these intrusions out of his body, that he had a helmet made of tin foil, and he became obsessed with trying to keep these voices out. That there were also times when he would be muttering to himself and he would just pace, and pace.
And there were, after that point in time, they were not able to live together.
Right. From my understanding, she moved to Tyler to be closer to her work position, and Mr. Gerard then lived in her home in Ben Wheeler by himself.
So we've talked about the mental status examination on page number 16, unless you think there's something else we need to talk about on that portion of your report.
No.
All right. So let's get to your diagnosis. And if you would give us a layman's version of what the diagnosis is, I'd appreciate it. So what is your diagnosis and diagnostic summary?
Schizoaffective disorder, bipolar type. So for this diagnosis, individuals have significant mood symptoms, and by that we mean periods of intense depression, and or periods of mania. So Mr. Gerard had both. But in addition to that, during manic episodes, people can have delusional beliefs, experience perceptual disturbances like hearing voices. But once that mood is treated, we would expect those psychotic experiences to no longer be present. So for Mr. Gerard, those symptoms are still present when the mood is treated. The auditory hallucinations, the delusional beliefs, and that's why I think his diagnosis is schizoaffective disorder, bipolar type.
All right. And as of the last time you talked to him, he still hears voices. Is that correct?
Correct. That's my understanding, yes.
Even with the medication he's taking?
Yes, he said that the voices still happen, but they don't happen as frequently. They're not as intrusive, and he's able to ignore them more so and use coping strategies to not be as affected and distressed by them.
So then the secondary diagnosis was stimulant use and how that relates.
Yes, so stimulant use disorder, methamphetamine type was the diagnosis that I gave him as well because of his history of using, having legal charges related to that use, trying to quit on his own, having a difficult time quitting when he wasn't in court-ordered treatment. And despite the stimulant potentially having a negative effect on him, using more often, more frequently than he wanted to, and not being able to quit. So he did meet criteria for stimulant use disorder as well.
All right, and then turning to the next page, let me read you a portion of that paragraph and let you explain it to us, please. Mr. Gerard has a long history of mood instability as well as psychosis during times when he had not had access to illicit substances such as methamphetamine, as evidenced by his records from Andrews Center years before his alleged offense. He has also had significant symptoms of paranoia, auditory hallucinations, and unstable mood for years after the offense, as evidenced by his records during his detainment, when he again would not have access to methamphetamines. And I think this restates what we covered. Is that correct?
Right. And there we're just looking at whether his symptoms were substance induced. So because of the effect of a drug, that when that drug wore off, he would no longer be experiencing. And so I was able to rule that out.
So let me just read that then. This would rule out the possibility that his symptoms were solely the result of a substance-induced mood psychosis disorder. It is my opinion, with reasonable degree of medical certainty, Mr. Gerard does have a long-standing severe and persistent mental illness, schizoaffective disorder, bipolar type.
Correct.
All right. All right. So one of the things that you looked at is whether or not Robert had indications of antisocial personality disorder. Can you explain to us what the antisocial personality disorder is and how you would determine he does not have that?
So antisocial personality disorder is really an individual who doesn't agree with the laws of society. So they don't respect those laws, don't follow them. To qualify for that diagnosis, you'd first have to start exhibiting those symptoms as an adolescent. So things like skipping school, being truant, torturing animals, physically assaulting people, sexually abusing people, that sort of thing. So the questions that I had for Mr. Gerard is if Mr. Gerard demonstrated those types of symptoms in his childhood, and she confirmed that he did not. Then I looked at whether there was evidence for that sort of. Often there can be times when people may not get that diagnosis, but still qualify for that diagnosis. But I didn't find significant evidence that he met criteria for that personality disorder. And during my evaluations, I didn't think he had that disorder either.
And that would include any psychopathic traits as well.
Correct. And that would be things like being very glib, superficial, not having empathy, not respecting the laws of society, having lots of legal charges, because one of the stipulations for being able to qualify for not guilty by reason of insanity in Texas would be that the conduct wasn't purely related to antisocialness.
All right. So let me talk to you first before you go into your final opinion. Let's talk one thing about the issue of dangerousness, which the court has to deal with. Of course, he's going to be. The evidence is pretty clear. He committed a first-degree felony murder. But when Robert is not using, or when he's unmedicated, does he exhibit some problems that would cause some danger to or possible harm to others?
So when unmedicated, he would have much more paranoia, suspiciousness, and would likely go back to having delusional beliefs about being stalked by various entities, like he had before.
But it doesn't look like, it looks like there have been some occasions where he's been agitated. I think there was reference to he was in some sort of, I don't know, verbal or physical altercation at the jail. But at that point in time, he was not medicated.
Correct.
And I think there's other evidence when he's not medicated, he may get agitated. So I guess the advice to Robert is you got to take your meds.
Correct, yes.
All right. All right. So then, I think we've covered it, but would you please, restate your opinion based on, reasonable medical certainty as to whether or not Robert meets the test for not guilty by reason of insanity? And
Yes.
a little more lengthy explanation, if you would, please.
Yes, so I diagnosed Mr. Gerard with schizoaffective disorder bipolar type because he had discrete episodes of depression, mania, and psychotic symptoms in the past, as well as during my evaluations of him that were present even despite treatment. However, with that treatment, Mr. Gerard was sociable, easily engaged. He wasn't someone that I was scared to be in a room with for 2 hours. But then, so first of all, he did have a severe mental illness. So then I looked at whether that illness was present at the time of the offense, or if it could have been related to methamphetamine use. And he did have methamphetamine use that he talked about using. But what was key about this is a drug test can tell you, yes, this person used, but it can't tell you how long ago. So especially with methamphetamines in someone who uses chronically, that drug test will be positive even as much as a week after the offense, which we wouldn't expect an individual to still be exhibiting signs of acute intoxication at that point. So what Mr. Gerard told me is that when he had been talking to Mr. Love smoking, that he had decided he'd had enough of that and he'd gone to lay down. And he laid down for about 60 minutes, maybe 90 minutes. So he said about an hour, hour and a half. Then he got up, he came back to the living room, talked to Mr. Love, but then realized Mr. Love was just telling the same stories all over again, which irritated him. So he went back to bed and then he slept for a period of 8 hours. So I would not expect someone who is acutely intoxicated on methamphetamines to be able to sleep that amount of time and still be acutely intoxicated. Also, I didn't see features of acute methamphetamine intoxication on the cameras. He wasn't agitated, restless, fidgety. He's able to sit still. He's actually calm, cooperative. And then on top of that, when looking at whether he understood the wrongfulness of his conduct, Mr. Gerard may have vacillated at points about saying, I was right, I was wrong. But when I talked to him about this specifically, he talked about Mr. Love as someone that he had loved like a brother growing up, and the gravity of what had happened really affected him. But at the time, he did say he believed that he had acted rightly in thinking not only that he had defended himself, but that he had saved children from being assaulted by Mr. Love, which is a belief that he'd had for some time. He also talked about having questioned Mr. Love about that belief prior to the offense. So I think all told, he did truly have a severe mental illness at the time and not understand the wrongfulness of his conduct.
So, one more issue on the drugs. The toxicology results showed that he had a small indication of methamphetamine. You recall that? Very small.
Yes, so he did test positive. It was on the lower end and not what we would typically expect of someone who was acutely intoxicated. We would expect a higher level than what he had. In looking at case reports of individuals who have committed serious violent offenses and been acutely intoxicated on methamphetamines, they would often have a much higher result. But it does show that he did use at least within the last week. And by Mr. Gerard's own admission, he had used on the evening of October 21, 2021 into the early morning hours, but then said he hadn't used after that. So he had a period of withdrawing from that medication and then went to sleep for 8 hours, which would be evidence of withdrawal from that stimulant because once you withdraw from it, then you sleep a lot.
So the presence of methamphetamine in a tox screen does not mean intoxication. There's a difference, whether or not you're suffering the
Correct.
psychotropic effects of the drug.
It lets us know he used this substance, especially with LCMS testing, because then we know, yes, you use this. This isn't a false positive or a false negative. We know you use the substance, but it can't tell us if your use was 4 hours ago, 24 hours ago, or a week ago.
Okay, so let's talk about assuming that there is a verdict of not guilty by reason of insanity. That's one of the things you do is at the patients at Terrell's, you deal with folks that have this issue. Can you take us through what happens next with somebody like Robert? What's going to happen to him?
Yes, when an individual is adjudicated not guilty by reason of insanity, the court then sends their information to the clearinghouse at North Texas State Hospital Vernon campus, where their name is then put on a list of awaiting transfers. So when you have a serious offense like a felony 1, you're sent to a maximum security facility like North Texas State Hospital Vernon campus or Rusk, which also has a maximum security facility. Then that individual would have to demonstrate to their treatment team that they were following all the rules, taking their medications. They have to do that voluntarily, preferably, and achieve a higher level, such as grounds access, for example, because at Vernon, they have a fence around the campus. So if you get a high enough clearance, you can go outside on your own. When the treatment team then felt, or say they didn't think you were ready to pass a dangerousness review board, they still are routinely, I believe it's every 6 months or so, referred to the DRB, the Dangerousness Review Board, and the treatment team will make a recommendation. They'll either say this person we recommend is still manifestly dangerous or no longer manifestly dangerous. But to be found that's the recommendation of the treatment team. There's then a dangerousness review board held, which is a group of people made up not of anyone on that person's treatment team. So that would be, say, a psychiatrist from Terrell, a social worker from Rusk, a psychologist from Kerrville. So we're all over the state hospital system. Then we'll look at the dangerousness report that the treatment team has provided. The individual can also be present to provide testimony during that hearing. And then if the treatment team, generally if a treatment team is saying, hey, they're still manifestly dangerous, we're probably also going to agree with that. But if the treatment team was saying they're no longer manifestly dangerous, they don't make that decision. It would be the dangerousness review board that would make that decision. So then when they're declared not manifestly dangerous, they step down to a less secure facility like Terrell State Hospital, for example, and they would go through NGRI classes. So those are available at Vernon, Rusk, as well as Terrell. They have to be fully compliant with that program, meaning they go to all their classes, they take their medications. We try to get them on a medication like a long-acting injectable. That way we have, it's hard to take your medication every day. So a long-acting injectable assures that you're receiving that medication routinely. We document their behavior, their symptoms, and then when their treatment team feels that they might be ready to have a hearing to determine whether they would meet criteria for being presented to the court for an outpatient commitment, the treatment team would make that decision. If they thought they might meet criteria for that, they would then have a facility review board hearing by the superintendent, various other individuals at the hospital. And if that review board also agreed, yes, this person looks like they've made sufficient progress, then they would have a hearing by the court to see if they were ready. But ultimately, it will still be in the hands of the court. We can only make a recommendation. It will still be the court's decision whether he would be okay to go to an outpatient commitment. But even outpatient, you're still followed by the court. If there were to be an issue, they could reverse that and send you back inpatient. And the court maintains jurisdiction, for example, on a felony 1 for life. So it's up to the court to decide if they were going to at some point say, hey, you've done well enough in the outpatient setting. we don't need to keep following you, but it would be up to the court to decide.
So, so at this point in time, we're not be able to tell you, Robert, you're gonna be there for years, or it's gonna be years, I'm sure, that the way you're describing it, but there's no way to say how long.
There's no way to say how long. It's different with every individual because there's different social circumstances. So generally, the level of services available to an individual in the state of Texas, once an individual's been in the state hospital system for a period of, say, around 3 years or so, then they qualify for maximum benefit support. So then they have things like nurse visits several times a week, peer support several times a week, financial assistance to be able to maintain housing. They have follow-up with a psychiatrist, maybe even have an ACT team, like a group that would come out to where they're living, making sure they're taking their medications, that sort of thing. So they just have a lot more roundabout services than you generally see other psychiatric patients have.
All right, so I think I've covered everything on my list. Did you have anything else that you wanted to add at this point in time?
No, sir.
I'll pass it with witness, Your Honor.
Scurry, your witness.
Thank you, Judge. Briefly, Doctor, I just want to go over a few things that you said, make sure I'm understanding correctly. You diagnosed Mr. Garrard with schizoaffective disorder, bipolar type.
Correct.
Is that consistent with the diagnosis that he had all along from Dr. Corman, or is it a different diagnosis?
So initially, Dr. Corman diagnosed him with bipolar 1 disorder because initially Mr. Gerard was not experiencing psychotic symptoms. And then later in 2017, he actually receives a diagnosis of schizoaffective disorder, bipolar type, because he is experiencing psychotic symptoms. But that's not uncommon. We see this quite a lot in psychiatry, that people may start off with one diagnosis, then the next. There is an overlap of symptoms in those diagnoses. The only difference is that in bipolar disorder, when the mood is stable, they shouldn't still have those psychotic symptoms. But with schizoaffective disorder, those psychotic symptoms can occur even if the mood is treated.
And that was my next question. Does schizoaffective disorder always include psychosis?
Yes.
That's one of the prerequisites for the diagnosis. Is that
yes,
correct?
That they've had at least 2 weeks of psychotic symptoms without the presence of mood symptoms.
And does schizoaffective disorder always include hallucinations?
So it doesn't necessarily have to. It could be delusions or hallucinations, but one of those psychotic symptoms.
Okay. And is it true that Mr. Garrard had both?
Correct.
Okay. And why is schizoaffective disorder always labeled a severe mental disease, or does it vary in severity with individuals?
You know, every person's a little bit different. You would have some individuals with this diagnosis who maybe would still be able to maintain a job or a relationship. But generally speaking, it is much more difficult to do those things when you have a severe illness like this. It is a very severe mental illness, yes.
Okay, and that was going to be my follow-up then. What makes Mr. Garrard's schizoaffective disorder a severe mental disease as opposed to someone who may not have it severely?
Because of his impairment in functioning. He can't maintain a job anymore. He can't maintain a relationship. He's living by himself, paranoid, withdrawn from everyone, so not functioning at the level that we would expect someone with an above average IQ to be able to do.
Okay. So changing topics just a little bit. If I use the term tweaking, do you know what I mean by that?
Yes.
Okay. So in that, both videos, actually, the in-car video and the body cam video, did you see signs of tweaking, physical exhibitions of tweaking by Mr. Garrard in those videos?
No, I didn't.
And is that another thing that went into your formulation, you're answering the question of whether or not the symptoms he was exhibiting at that time were stimulant induced or mental disease induced?
Correct. That's something that I looked at really closely in this case because I wanted to make sure that I'm saying the mental illness is to blame and not, and when he's actually in fact acutely intoxicated on methamphetamines. So initially, I thought I would see features consistent with somebody who's acutely intoxicated on stimulants, and he didn't actually exhibit those.
Okay, and just so the record's clear, tweaking, I guess, is a colloquialism for severely intoxicated on methamphetamine or some type of stimulant. Is that correct? The fidgeting, the picking, all of that.
Yes,
And you didn't see any of that on the video.
I didn't see that. I do think some of that is because of the way Mr. Gerard used. So when you smoke it, you get the effect really quickly, but it also wears off much faster than, say, if you had eaten it or taken it in some other way.
Now, I want to talk just a little bit about the second prong of the insanity test, that the mental disease or defect caused him not to know that his conduct was wrong at the time of the conduct. The hallucinations and the psychotic incidents that you point to, and even the ones that he talks about somewhat in those videos, include voices of people raping his mother and daughter. Is that correct?
Correct.
As well as you mentioned, law enforcement agencies intruding into his thoughts, trying to control him.
Correct.
Okay. During the time, based on what Mr. Gerard reported to you and to the officers at that time, was Mr. Love, particularly Mr. Love's voice, intertwined in those psychotic events or hallucinations?
Yes.
Okay. And can you elaborate on what led you to believe that?
So, Mr. Love, and initially, so when you're looking at what sort of auditory hallucination someone has, you want to match that up with what we would typically see and what would be really atypical. So his was very typical, hearing family members, close relatives, people he knew talking to him when they're not around. Then, when he was living with his mom, questioning her, feeling suspicious, like, is she actually telling me the truth? Why is she not admitting this? And then also hearing strangers. For example, the constable in Van Zandt County that he was convinced was stalking him to try to prove things against him that he hadn't actually done. That's also consistent with what we would see with an individual with an illness like his. And then he told me when I asked him about hearing Mr. Love, he said he'd actually questioned Mr. Love about he would have these obsessional intrusive images being, as he thought, beamed into his head, and that were really distressing, of all the women he loved being abused in some way, very emotionally distressing for him. So he'd questioned Mr. Love about that. And he said Mr. Love had denied it, but he was convinced that Mr. Love did know what he was talking about.
And in fact, in those hallucinations, Mr. Love's voice was involved in the acts that were being committed against the women he loved.
Correct.
You talked about what happens next. That period of inpatient treatment at the first highest, most restrictive step can last, if necessary and if deemed appropriate, for the maximum term of imprisonment for the offense the person was found not guilty of.
Yes, that's right.
So in this case, we don't know, but he could be in a secure facility for the rest of his life.
Yes.
Or he could earn the right to step down.
Yes.
But ultimately, is it true that he will never see life outside a facility without the approval of a judge and a court?
Yes, that would be right.
I'll pass the witness, Judge.
Mr. Lowe, your witness.
Nothing further, Your Honor. Rest.
Any objection to Dr. Lampley being finally excused?
Oh, Your Honor.
No, Your Honor.
Thank you, Dr. Lampley, for you being here. Anything further from the defense?
No, Your Honor, defense risk.
Close? Close?
Close, Your Honor.
Would y'all like closing arguments at all, or just leave it with the board? No?
No, Judge, I think we're both going to ask that the court return a verdict of not guilty by reason of insanity. I've been researching today, Your Honor, the written judgment, if that is the court's verdict. We did, with Patty's help, get a form. It looks very different. It's not a typical judgment form. I don't have that completed yet. I can complete it for the court. Mr. Lowe can, the court can do it itself, whatever, but we're available if the court wants assistance with that.
Okay, thank you. All right, this is what I would like to do. I would like to take all this under advisement, give me an opportunity to review the state's exhibits, the defendant's exhibits, and reread Dr. Lampley's report. And I would like to come back on December 17th and issue my verdict at that time. Are you available on that day, Mr. Lowe?
I think I've got something in Judge Winter's court. Let me see, Your Honor.
I don't believe I'll be here that day, Judge, but Mr. Hartwell can certainly handle anything.
What about next Thursday, December 5th? Is that better? About the same?
Same thing. That's the annual electeds conference, Judge, so same thing. But Mr. Hartwell and Mr. Hernandez can handle it.
Yes, sir.
What time of day are you thinking about, Your Honor?
Are you looking at the 17th or the?
On the 5th, because I've got a ultrasound on that day. I'm just not sure what time it is.
On the 17th?
On the 17th, I've got to be in Judge Winter's court for a hearing. And then on the 5th, I'm not sure if I've got to have an ultrasound related to my heart. So I don't know if it's ready in the afternoon or the morning. I have to get back to you.
Well, we'll just do the 17th then.
Yeah.
On the 17th, I've got a hearing in Judge Winter's court.
I mean, all day here?
Well, I don't know, Judge. We should be through by 2:30.
This will be quick, Doug. We can do it. We can do it. This will be quick.
Okay, do the 17th then, Your Honor.
Yeah.
That works.
Well, we can set it late in the afternoon. We'll just, let's set it for 3 o'clock, 3 o'clock on the 17th. And then if you're still working downstairs, then we'll just be patient.
Okay,
Fair enough?
yes, sir.
That should give me an opportunity to get through my afternoon cases that are on the regular docket.
Yes, sir.
We'll start as soon as you're available that afternoon around 3.
Thank you, Your Honor.
All right, let's go ahead and fill out a notice of settings just so I can have it on the record. Here, I'll do it.
You want, Mr. Gerard transported here that day, Judge?
I'll make that determination and I'll let Patty know.
Okay.
But most likely we will. All right, I don't need him to sign it. I'm just gonna give him a copy of that and file this originally. All right, if there's nothing further in this case, then we're adjourned.
Well,
Thank you, Mr. Lowe. Thank you, Ms. Curry. All right, I believe that does conclude our criminal docket today. I don't believe that we had nice eyes.
an issue.
We are adjourned.
It's gonna be over there.